Good morning. Welcome to the November 2020 meeting of the Indiana Justice Reinvestment Advisory Council. My name is Chris Goff. I am an Associate Justice on the Indiana Supreme Court, and I serve as Chief Justice Loretta Rush's designee to chair Indiana's J-Rac. I want to thank all members of J-Rac or their designees for participating in today's important meeting. And it is my great honor to serve as chair in this important work on behalf of the citizens of Indiana. Later on in today's meeting, I'm going to be calling on J-Rac members or their designees to give a brief report out on the important work being done in their individual agencies. Before I do that, however, we're going to have some business. And the first item is approval of the October 28th, 2020 meeting minutes. Prior to this morning's meeting, a copy of those minutes was distributed to all J-Rac members. I'd first ask all members if there are any recommendations for changes or corrections to the minutes. And if there are none, I would entertain a motion to approve the minutes as presented.
Ralph Watson, so move.
Thank you, Ralph. There is a motion to approve the October minutes as presented. Is there a second?
This is Devin. I'll second that.
Thank you, Devin. And Devin McDonald has seconded Ralph Watson's motion. Is there any further discussion? All those in favor of approving the October 2020 minutes as presented, please indicate by saying aye.
Aye. Aye.
Any opposed? Motion carried. Thank you, Ralph. Thank you, Devin. Next, I would ask for a report from the J-Rac Quick Response Group. There are two items for discussion today, two general items, but the first is an update and discussion of case studies on local jail populations during the pandemic. And I'd ask Mary Kay Hudson to present a brief report out on behalf of that group. Mary Kay?
Yes, good morning. Good morning, everyone. Thank you, Justice Goff. I just wanted to update the group. At the last meeting, I had provided with the assistance of the other quick response group members that we would provide a summary, or we provided a summary of our review of the local jail populations pursuant to any changes in policy and practices that they had made as a result of the pandemic. So we provided an overview of our findings regarding that. I had intended to have a written report to submit to J-Rac for official approval. I have not completed that yet. So I just wanted to update everyone and let them know that I intend to put that together, circulate it to the jail group members and for their approval, and then submit it to J-Rac for approval at the December meeting.
Thank you, Mary Kay. We'll look forward to hearing from you then next month. The next general item then is a discussion and perhaps a vote on legislative proposals. We have two items to consider and to hear about today. The first is the idea of the local J-Rac policy teams. And I'd ask for a report out from Representative Fry, Chris Blessinger from the Department of Corrections, and Mary Kay. Good morning, everybody.
Good morning, Justice Goff, and thank you so much for giving me an opportunity just to talk a little bit about this legislation. I think the members of J-Rac should have had a copy of the legislation, or the PD file, I should say, sent out to them. We got a little bit of feedback on the PD, and we'll be happy to listen to additional questions or comments that the members might have, so we can adjust this PD and decide whether we're going to go forward with it. We still have a little bit of time, but happy to hear the comments of the group.
Thank you, Representative Fry.
Representative Fry, there were two items that were submitted from J-Rac members since we distributed the preliminary draft. The The first was regarding the frequency of meetings. I think
it's line 35.
Requires I'm sorry?
It's on line 35, I think page 2. I did make that note, and that it is probably just a misunderstanding between myself and LSA. We'll take care of that. And then the other one was meet jointly with community corrections advisory boards. From my perspective, I have no problem with that. Makes sense to me. Just wondered what the rest of the board would think about that.
And Mary Kay or Chris, I just wanted to make sure I knew that there were some revisions from the initial draft made at the request of the Department of Corrections. What is the request of the group for purposes of today?
Okay, can you hear me?
Yes.
Okay, sorry, a little technical difficulty. So I know that I know Mary Kay that you had sent an email about maybe making some discussion. So I didn't know if there was some further discussion we needed to have based upon what we had talked about at the last meeting.
Well, I think upon our review of the suggestions, the proposed language from DOC, we had suggested that there could be some merit to including it as a non-code provision. So I think we wanted to talk with DOC about their willingness to take a look at that. But I don't know if other members had any other feedback or questions about the concept generally, about having J-Rac study the community correction statutes. Justice Goff, I don't believe that any specific language has been forwarded to this entire group. I think it's still under discussion as a concept at this point.
And I appreciate that. Just for clarification, I wanted to make sure that the group that's working on the local J-Rac concept had the opportunity to ask for what they wanted from the group today. And it was my understanding from Representative Fry's comments that he would like to make sure that everyone who wants to give input or express concerns or support had an opportunity to do so before he advanced the legislation. I know we're going to meet, the plan is next month, but I also know time is of the essence. So perhaps the most prudent thing to do at this point was just ask if there's any comments or questions from members of the group so that Representative Fry, Chris, and Mary Kay have an understanding of those going forward from today's meeting.
Sure. This is David Bottle.
Go ahead. Sorry.
I'm sorry. I stepped away from my computer because I was having a little bit of connectivity problem, so I'm on my phone now. So if I show up twice, I apologize. The comment about could the community correction board serve in this capacity came up from one of the smaller counties who felt like they already had a little bit of difficulty getting a quorum and participation in community corrections. So if they had to create a similar board with many of the same membership or agencies represented, it may create even more of a problem as far as attendance and people willing to attend. And I think somebody from our group too also mentioned about, do we want to put in statute that they have to meet twice a month? And Representative Fry mentioned that, maybe initially, the comment I got back, maybe initially they should meet twice a month to get the ball rolling, but after that, they should perhaps be able to set their own frequency of meetings. So those are the two comments that we had from Association of Indiana Counties.
And Justice Goff, I think Dave and I are kind of on the same page on this. And I think in my comments as well from the judicial perspective, the sort of the logistics of the meeting were just the only concern there. And similar to Dave, being able to meet jointly as CCAB as well as the J-Rac, as local J-Rac board, I think would be, just specifying that, I think would be helpful. And then also the meeting frequency issue as well. I would tend to agree with Dave that maybe this body might be might want to meet more often at the beginning, but you would want to be statutorily required to meet twice a month. And so, you know, I think if the statutory requirement was every other month, I think that's probably something that would be a lot more workable. And I think that was the initial concept.
Yeah.
Justice Representative Fry, I'm happy to make those changes, and we'll be proposing them to LSA tomorrow.
Thank you. Anything
I know
else?
as far as the community corrections, which we talked about at the last meeting, and, you know, being able to study and review language and make suggested changes. I know our Department of Correction is planning to meet with Representative Fry, I believe, this week. So we definitely appreciate his willingness to meet with us and discuss. So I guess at this point, you know, we need to have some further discussions on our end.
Sure.
All right, we're meeting tomorrow.
All right, thank you. Are there any other members that would like to express questions or ask for further clarification before we move on to the next item?
Justice Goff.
Yeah, good morning, Chris.
Hey, good morning. Thanks, and thank you, Representative Fry. The question I had is on the very last page, page 3, and the very last line, and it's a requirement for the local advisory council to perform other duties as required by the state advisory council. And I'm just trying to envision what that might be. Somewhat broad, and it's, you know, it will be viewed as it is a requirement, but I just was looking for a little help as to what we would envision that's not already covered or captured in the rest of the language.
I'll be happy to check tomorrow with LSA and see why they included that. If the body would like for me to strike line 29 on page 3, happy to do that as well. I just need a little more feedback, I suppose.
I appreciate that question, Chris. One of the things that I thought about when I saw the proposal, and I think that this, I hope partially responds to your question, but then also to the other concerns that were mentioned as to frequency of meeting, and then also as to corresponding existing bodies that might fulfill this function. As we go through as a state body and we're trying to do things like gather meaningful data to inform policy, one of the challenges is that there are probably not 92 different ways to gather data, but I would say probably 84 or 85. And if we as a state team were able to come to some consensus as to important data points that we might want to collect, I can see a real value in having, for example, a local body that was responsive to those data requests, so that we might have a designated point person in each county that this body could communicate with and say, hey, you know, we're really looking at this issue of, you know, time person's held until initial hearing, time before a person comes and is examined if they're found to be, you know, or you know, there's a request for examinations to competence, things like that, and any number of data points that might be valuable. So I just, I see the concern, but I also think that it might be helpful to have that group so that we could, you know, actually move some state initiatives forward and be speaking language. So just for what it's worth, I hope that that's something that the team maybe thinks through and consider some areas in which it might be helpful to have a group there that was responsive to you know, concerns of the state group. Going forward then, what is the request of the small group though? Are you asking for support for the general idea with an idea then that we would continue to work and clarify the language before the next meeting, or what is the request of the group?
Yes, Justice Goff, I think that's exactly what I'm looking for. And as you know, we're running out of time. We're going to need to finalize this legislation and get it filed pretty soon. So that's what I'm looking for, sir.
Well, then with your permission, then I suppose that's what I would do is I would ask April to get this on the meeting agenda for December. And then I would ask all members to please be on the lookout for revised language, be prepared to express any concerns with an eye towards an ask for support to the extent that you're able to voice it or not, so that Representative Fry knows what he has going forward.
And Justice Goff, the only thing I would add is that whatever we start with doesn't have to be what we finish with. As we move through the process, we can amend the bill, we can make changes as we learn more about the process. So even though we may get started with something that someone has an objection with, we're happy to work within all the group and try to get the best bill we can going forward.
I appreciate it. And thank you for doing the hard work carrying this forward. And thank you for participating in the discussion, Chris, Mary Kay. Thanks for your concern and your review, Chris and Ralph, Judge Spitzer, and David. All right, well, very, very well. Then the next item for consideration, discussion, and possibly vote are proposed amendments to Indiana Code 3533-838. And reporting out on that issue were Senator Talion, Bernice Corley, and Chris Naylor. So anyone who wants to speak, please.
Is Senator Talion on? I thought, Justice Goff, the last discussion or where it left off was that Senator Talion was going to reach out to Judge Spitzer and have a conversation, but I'm not, beyond that, I'm not aware of any other conversations.
I think that's right, Bernice. And I actually have a meeting with Senator Talion tomorrow on this. And so she did reach out. We do have a meeting set. We just weren't able to get connected prior to this meeting based on both of our schedules. So we will be meeting tomorrow. I did have some concerns that I had expressed in the previous meeting. And then I've also kind of run it up the flagpole with the Judges Association just to double check me, and they had similar concerns. And so I think that those are things that would need to be worked through. I don't want to speak for Chris, but I think Chris might have raised some of the similar concerns that I had raised.
Well, Bernice, Judge Spitzer, thank you. Chris, do you have anything to add?
No, Judge Spitzer is correct. We had some ongoing concerns and just haven't seen the language that we could be supportive of to this date. So thank you, Justice.
Well, thank you. Well, if none of you on the small group have any objection, then I think I'll do the same thing as I did with the last item, and then just ask April to add it so that we can check to see where we're at going forward in December.
That'd be fine.
If I might.
Yeah. Good morning, Representative McNamara. Please.
We are in the middle of the CSG study of juvenile systems across the state of Indiana. And I want to be hesitant in moving forward with any juvenile changes until we really get feedback on what we look like as a state to make sure we do it appropriately. So I just would like to add the hesitation in there to make sure that we don't make a change that we're going to have to make again once we get the results back. So just wanted to say that.
Always appreciate your input and the update. So is there any objection then to just going back and seeing where we're at on this issue in the next meeting in December?
Does that make sense?
Very well. Thank you. So moving forward then, the next agenda item, and this is something I'm particularly excited about, and I'm glad to share it with the larger group. A project that several folks on this call have been working on for the past a little more than a year is improving court and community response to persons with serious mental illness. And Jay Chaudhry is going to be speaking about one very important subset of that subject. And we have a guest speaker today here who I'm very anxious for you all to hear from. His name is Rick Schwimmer, and he joins us from the National Center for State Courts. But this project in Indiana really started about a year ago when a group of us, including Doug Hunsinger, Jay, Mary Kay, Justin Fortner, Sheriff Brett Clark, and Senator Sandlin attended a regional meeting in Deadwood, South Dakota, to learn about really cutting edge practices for improving court and community response to persons with serious mental illness. And Rick is assisting Mary Kay and other important stakeholders in our mental health delivery system in mapping out mental health delivery in Indiana and really trying to figure out where the choke points are, where we're doing things well and where we need some improvement. And, you know, we're really excited to have the opportunity to do this because this problem affects so many of us on a daily basis. There's certainly a terrible human cost involved, but there's also a financial cost involved in not doing this right. And so probably the area of greatest concern, most pressing, is this problem of competency restoration. I know that's a concern for sure to the sheriffs and to the folks at DMHA. So I'm going to call on Jay Chaudhry to make a presentation to the group today on some of the exciting work that's being done in this area. Good morning, Jay.
Good morning. Let me just share my screen real quick. All right. So thanks, Justice Goff. I appreciate you giving me the opportunity just to kind of set the scene here. Sorry, I'm having a little trouble here with these animations. I should have disabled them. So I appreciate you giving me the chance to set the scene here because there's a lot of, I'll be honest, I didn't know anything about the state psychiatric hospitals before I joined DMHA, and I suspect that's kind of the case across the board. And I think that some folks know that they exist and that they are the remnants of what once was a huge psychiatric hospital system that at one point served over 55,000 Hoosiers and now is down to about 800. So I just thought, it'd be important to sort of know what are the state psychiatric hospitals first, and then we'll talk about competency restoration. I'll also share that one of the questions I've gotten since I've been talking about this for the last year or so is, why are you focusing on this? Why not focus on, the bigger issue of mental health in jail in particular? And the snarky answer to that is, it's possible to walk and chew gum at the same time. But the serious answer to it is, number one, this is a very, very sticky point in the system. This gums up the works kind of across the board, number one. Number two, it's sort of a discrete thing that we can, make some progress on as we focus on chunking this huge problem, into manageable segments. And so, here's the hospitals. They're kind of all around the stage, you can see. But more importantly, what are they, sort of as an existential level is like a really important question to answer. And I think that the truth is that there are very, very differing views between probably most of the folks on this call and the way the hospitals see themselves and are set up to operate. Hospitals, we see ourselves in the hospitals, the people that work there see themselves as kind of specialized medical institutions with a very specific targeted set of programming and services appropriate for only certain patients. I think a lot of folks in the justice system especially see the hospitals as kind of the next stop on the continuum and sort of the last stop to put people once other options fail. And, I think that the truth is probably somewhere in between. I think that the bottom line is we need to get a better understanding and sort of a common understanding of what exactly are the hospitals. And so, I'm not here to offer an opinion here. I can answer some questions about that. I think that the truth is probably somewhere in the middle. I think that, it does not make a whole lot of sense to send certain people that currently get sent to the hospitals. On the other hand, we have to recognize the reality that we have a very limited spectrum of options for some people. And, it's only fair for the psychiatric hospitals to be part of those options. Some of the challenges with the hospitals, sort of the main one, as usual, is financial. As we know, there's sort of two ways to improve your finances. That's to either get more money or reduce costs. And both of those things are, if not impossible, extremely, extremely difficult, to the point where they're more or less impossible for the hospitals. And that's because there's this federal provision called the IMD exclusion. IMD stands for institutional mental disease, which means that they're for patients in the state psychiatric hospital, or really any inpatient psychiatric hospital between the ages of 22 and 64, there is no federal money that can be used for that. And so, almost all of our patients are indigent, so they would be on Medicaid if they were outside of the hospital. But because when they're in the hospital, they cannot draw any kind of Medicaid reimbursement. And so that means that cost, which is about $800 to $1,000 a day, is all state money. So that is obviously a huge issue. And then cost cutting is also very difficult because we cannot do more with less. It's not possible to do so in a psychiatric hospital setting. As you know, we're mandated by statute to take our patients. We're hospitals, so we have to meet the sort of standards of the Joint Commission and Center for Medicaid Services in order to stay viable. And as part of that, we have a standard of care that requires lower staffing ratios. We have so many patients right now that literally have to be on a 1-to-1 at all times. And that's just like it sounds. There has to be one staff person for one patient at all times, 24/7. Some of the folks that are in the correctional setting, we should probably specifically note that we cannot lock people in a room absent of targeted specific medical order. That's called a seclusion. We're not allowed to do that. So if we have a problematic patient that requires more attention, we have to give them that attention. We can't just lock them in a room and throw away the key. Not saying that we would want to do that, but some of the avenues available to some other institutional or facilities are not available to us. So finally, we're talking about incompetent stand trial. I think it's important to kind of know what exactly that is. It's really two questions here. Does the defendant understand the proceedings, and can the defendant assist in the defense? Now, this is generally brought up by the defense attorney, but it can be brought up by the judge or the prosecutor or any party to the case. And so this is sort of the flow chart right now as it stands. And right now, as I'll get to, there's kind of only one path through this system. There's a competency evaluation, which I think the Rick will get to some of the stuff and some of the ways we can maybe tweak this to make the system a little more efficient when he presents. But this is kind of the main thing right here. Look, if found ICST, the defendant has to be committed to DMHA to receive competency restoration services, regardless of any sort of notion of medical necessity. So competency restoration, I think it's important to note, is not just treatment. It's treatment, but it's also legal education. So there's the treatment component, which is what we usually think about when we think of psychiatric treatment, medication and therapy, skills training, that sort of stuff. And there's also very simple basic legal education to get the patient to the point where they can understand the very rudimentary, kind of elementary level of their criminal case. So this is something that's just a gap right now. We have a lot of folks right now who are probably unrestorable. These are people with intellectual or developmental disabilities, a growing population of people with traumatic brain injuries, just people that will never be restored. Right now, they're treated, at least initially, they're treated the exact same as the people that have a good chance of being restored. And so, what happens basically is they stay with us for 180 days. We're required by Indiana Supreme Court case of 2014 to, even if they have advanced dementia, for example, and there's no hope of them ever getting better, we still have to try according to the statute right now. And so we try for 180 days. If they don't, if they don't regain competency, then we have to go for a civil commitment. Sometimes that civil commitment is granted. Usually it's granted, although increasingly the civil commitment is being not given because there is a gap between the civil commitment standard and people that are found in ICST. One does not necessarily equal the other, although a lot of times it does. So, that's a problem that at some point we have to figure out, although, it's been pretty sporadic and minimal so far. And so, finally, here's what we're trying to do in order to kind of unclog this pathway right now. The road that's built there that you see is the only road that exists right now in the state of Indiana for competency restoration. That's at the state psychiatric hospital, and that road is jammed up. There should be a ton of cars on there, people beeping and honking, and it's just a mess. So what we're doing is we're actually building 2 other roads, but we're building them from scratch, right? So these are brand new things in the state of Indiana. So they are taking a while to build, although I think we're making progress. And that is providing competency restoration in 2 other settings, the jail and the community. And so some of those details are being worked out right now. We have a couple pilot programs underway in Marion and Vanderburgh counties to help work out some of the kinks. I will tell you, it is spectacularly complicated contracting. And so we're working through some of the kinks right now. But, just like other construction projects, it's sort of slow going. But once we can build those roads, the road in the middle, the traffic should clear up. And to kind of keep that analogy going a little further, we've also started a very small scale pilot program. And what we're doing there essentially is we're letting folks drive on the shoulder here by possibly sending appropriate people to private inpatient psychiatric settings and paying for their placement there. But the thing about it is it's only the vehicles that can fit on the shoulder are the ones that are appropriate for that. So it's only going to be a very small subset of the patients, that basically the ones that we can convince our private partners to take. So hopefully I didn't mangle that metaphor too much, but I think that it's probably the best way to illustrate what we're doing right now. So at that point, that's all I have, and I will stop and see if there's any questions.
Justice Goff, may I?
Yes, Bernice, please.
Jay, and I may be getting ahead of things here, but after listening to your presentation, you shared a concern is the required effort at restoring competency for people who are not capable of being made competent. The draft that J-Rac has before it today, touching on this, does that draft address that population at all or no? And if no, then what do you have suggestions for how this could be addressed, or is that sort of evolving right now?
I don't believe, Mary Kay, correct, I don't believe that the draft legislation addresses the unrestorability piece of it. And the reason is because it's so complex, because I mean, there are very real public safety implications to that piece, right? Because I think that the answer is, I think, for people that are not dangerous, that if the prosecutor could just agree to drop the charge, then we can go on our way. But there are folks who are unrestorable and have committed or alleged to have committed some pretty gnarly crimes and are probably or potentially dangerous. And so that simple drop the charge isn't quite what we're able to do there. So I think California has like a very convoluted, and Rick might be able to talk more about this. There are a couple states that have, I think, very convoluted answers about what to do about unrestorability. But, right now it's sort of a reflection of the lack of other options available. Like, for example, we have a guy right now in a jail, a county jail, who has advanced dementia, has actually not been charged with a crime, is not ICST, but is being held on kind of like a safety sort of situation. But no nursing home will take him because because of his psychiatric acuity, he is not appropriate for the psychiatric hospital at all. There's nothing we can do for him, but we're getting a lot of pressure right now from the judge and the jail to take this person on. Because there's no way to force a nursing home to take people on. So that's like an illustration, I think, of of the very real gaps that exist. And until you fix those gaps, you're not going to be able to fix the statute, right? Until you provide an outlet that actually exists, whether that's a state-run nursing home or a, something to that effect, you're not going to be able to do anything on the statutory end, because they'll still run into those roadblocks.
Good question, Bernice. Thank you, Jay. Are there any other questions for Jay before we move on to the second part of our presentation on this important issue? Well, again, thank you, Jay. I can't tell you how much I appreciate the time that I've been able to spend with you and your dedication to improving this delivery system in Indiana. I've worked in this area my whole career, and I recognize it's a problem, and it's a real tragedy because these are human beings, and it's a real cost because it's so expensive. The next presenters are Rick Schwirmer, who I mentioned, and I neglected to mention, I apologize, Patty Tobias. As the members know, I spent 12 years as a trial judge in Indiana. And one of the great things about being a trial judge in Indiana is if you get into a problem, you can call smart people like Mary Kay Hudson and ask, what do I do with this? I've never seen something like this before, and they'll walk you through it. And one of the really cool things I found out when I became an appellate judge in Indiana is that when we get in trouble at the Office of Court Services, we can call really smart like Rick Schwirmer and Patty Tobias, and they've got an idea that about how to help you through. And they're going to present some really high-level thoughts on this idea of mental health delivery and competency restoration. And I want you all to do me a favor, if you would. Mary Kay and I had a conversation about how to drop this on everybody last week. And this is something that when I speak to a constituent group like the Sheriff's Association, I recall a year ago, Steve asked me to come and speak to his members. And this is what I wanted to talk about, because I knew how helpful this would be if we were able to improve competency restoration for sheriffs. But when Rick helps us develop this statutory language, which you all saw, and let me just tell you, this is cutting edge. This is like probably the first time all of these thoughts have been coalesced and dropped on a state, or it's at least one of the very earliest. It's ripe for local input, and we're going to need you all to be committed, if you see this as a problem, to letting us know what you think is good, what you think is bad, what you think needs to be tweaked. But Mary Kay and I were talking about, the very idea, we don't have this big delivery system component of what do you do with these folks that are sort of weeded out of the criminal justice system right now. We don't have a good answer for them, and that's a cost that's associated with it. And Chris asked a question earlier about asking locals to do things that the state council thinks are important. This is one of the things I see as maybe important, really kind of keeping an idea or a number of the folks that are in your jails that are in need of these services. So this is not a quick fix, unfortunately, but it's one that I think is important enough that we really stay committed to it. So that's sort of a long-winded way for me to introduce two people that I've come to know over the past year, and I really respect immensely. And I'm very grateful to both of them for taking some time out of their schedules to share this work with you. So Rick and Patty, please take it away.
Well, hello, my name is Patty Tobias, and I will just say thank you to this group for your interest and commitment to this work. We have learned over the past year to be frankly horrified at what we're seeing in many jails across the nation, where people who have a serious mental illness are languishing in jails because they are found incompetent to proceed. So for purposes of due process, they're instead languishing in jail because we don't have in many of our states the appropriate processes, practices, and frankly, capacity to handle what's occurring. And so I am thrilled that for only the third time in the history of Chief Justices across the nation, that they have appointed a national judicial task force to examine the state court's response to those with mental illness. And this task force has taken on the horrible, frankly, issue of competency evaluation and restoration. With that, I'm going to turn it over to the national expert to talk about what we're seeing as approaches that states can take to begin to resolve this, again, very serious problem. And so again, I can't thank you enough for undertaking this, and also to shout out to Justice Goff and Mary Kay. You have some of the finest leaders that we've seen across the nation. So again, our thank you for their leadership. And with that, I'll turn it to Rick Schwarmer, the expert in this area. Thank you.
Thanks, Patty. And I don't know how much of an expert I am, but I have been working on this project for almost 2 years now. And what that's afforded me is the opportunity to see what other states are doing and to meet with groups in other states who have had similar thought conversations such as this to see what works and to see how we might improve the process in Indiana. The other thing I want to say at the very beginning is I'd like to extend my appreciation to all of the members of J-Rac with whom Mary Kay and I have already taken so much of your time. Mary Kay and I have met with, I don't know, 6 or 7 folks, I think, so far on J-Rac and other affiliated partners in this process. And again, as always, when I go to other states, I learn as much as I think that I impart in the way of knowledge. And so thank you to all of you that have taken the time. With respect to the competency legislation that you have in front of you, understand that this is by no means a final product. I was the state court administrator in Utah and represented the state of Utah with the legislature for almost 30 years. And I know that the way these things begin is much as was referred to at the beginning of this meeting. Let's get an idea out. Let's get everybody's input. We can amend a bill if we decide we want to run it. We can add things and take away from it. And so in that spirit, I think Justice Goff asked me to just very quickly put together some of the thoughts, some of the low-hanging fruit, if you will, that became apparent as we talked about how things worked in Indiana, because things work very differently in each of the 50 states. But there are some themes that we've learned about in other states. There is a fair amount of research about the competency process and what works and what doesn't. And so it may be dangerous, but to pick up on Jay's analogy, what I'm going to suggest are maybe some off-ramps from the road to the state hospital, and maybe some ways to increase the speed limit. Let's try those and see how they work. So I see April's brought up, again, this was just a very quick first draft to try to get some of these things on the table. So let me walk through them really quickly and then we can take questions that may be more appropriate. So the first thing that we notice as we look at the statute, just going in order in section 1, is that currently Indiana has a process of a requirement of appointing 2 or 3 evaluators. So these are forensic psychiatrists. These are folks with PhD psychology degrees who engage in the process of evaluating a defendant to make that determination about the 2 prongs that Jay mentioned earlier to determine whether they're competent. There are a number of states who have only 1 evaluator perform that function. And again, the information that we have, because we're early in this process, is imperfect. But as Mary Kay and I talked with folks, there were very few examples where judges or attorneys saw 2 conflicting opinions from the 2 required evaluators that are required now. So one way in which we can make things faster and get folks out of jail more quickly or into treatment more quickly would be to appoint 1 evaluator rather than 2 or 3. And that has a couple of effects. 1, as I mentioned, it makes it go faster. 2, you may be able, if you want, to increase the qualifications elevate the qualifications, minimum qualifications for those evaluators. So in this draft, I deleted physicians only because it wasn't clear that that was ever used anyway. But again, the idea is that you might be able to increase, by reducing the number of evaluations to be performed, you can increase the qualifications of those that do it and move things along more quickly. If you go further down, of course, if there's an objection, if any party objects to the recommendation that that evaluation just doesn't look quite right to me, sure, then you can require a second evaluation to clarify any concerns. Excuse me. If you go further down, another technique that we found in some other states, the evaluation reports themselves sometimes can be conflicting in the way they're drafted and the way they're constructed. They can take time and effort to clarify exactly what the evaluator found and the bases for which on which their opinion was based. And so another really simple thing would be to require that the evaluation and findings use a template, so that there's a template for the form that the evaluator uses, so that everybody knows that the factual findings are in subsection 2 and the legal conclusions are in subsection 3 or whatever it is, and that all of the information is consistent from evaluation to evaluation. There are several states that have done that. We have examples of that. Minnesota does that. Arizona does that, and we can give you some of those. And that may speed things along and make things a little bit more useful as well. The next thing is a concept that I think Justice Goff referred to earlier, and there are a couple of ways to approach this, and that is the competency process is expensive, it's long, people are in jail for a long period of time, particularly during the pandemic, waiting for a bed for restoration. And if we can perhaps divert some of the cars from the road at the front end, do we really need to go through that entire process for a misdemeanor who is charged with a nonviolent offense but is clearly seriously mentally ill? For those folks, maybe we can make a threshold at the beginning, a threshold determination that if they aren't dangerous and there is no reason to make them go through the entire process, expensive as it is, let's just divert them from the system. Many states have done this. The standards are different in different places. What I suggested here is that you may determine if there's a significant state interest in continuing the prosecution that outweighs the defendant's liberty interest. That's one standard. You could also do, as some states have done, which is simply to say if it's a misdemeanor, then they're excluded from the restoration process if they're found to be incompetent. So Ohio is looking at that. Hawaii just did that. Texas has done that. California, as Jay mentioned, has a process, complicated as it is, that goes in that direction. Florida does that. New York does that. There are a number of states that have already done something like that. So again, it's the concept rather than the words on the page in this event, but give some thought as to who you really want to subject to this process and this machinery of competency that is so expensive and so long. And if there isn't a significant state interest, let's divert them to treatment. Again, some of the mechanism of how to do that, I got some feedback that Jay may have had some ideas about how to do that statutorily. Again, this is just a first draft, rough cut, and we can talk about that further, but that would be the idea, is to divert those folks to treatment early on and out of the criminal justice system. There's also some technical language at the bottom of that section, that first section. Jay mentioned that there had been some issues about them contracting with third parties. And so I don't know if this is addresses the concern you raised, Jay, or not, but that's the some or all competency restoration services contracting that we talked about. If we go down to subsection 2 there, timelines is a whole separate issue. There are entire law review articles and psychiatric treatises written on the appropriate timelines for this process. Right now, you have a restorability determination that's required within 90 days. Excuse me. And so to the earlier question about whether we do anything to Bernice's question, this may be, there's a little footnote there, footnote 6. A lot of times clinicians tell me that it doesn't take 90 days, that really once we have somebody stabilized on their medications, then we know whether they're restorable or not. So you may be able to shorten this time period from 90 days to 45 days or 30 days or 60 days, whatever it is. And once you make that determination of unrestorability, then maybe we need to look at how we can off-ramp them from this road at that point. But remember that every day we save in the state hospital or in one of the state hospitals is $1,000. So that's one place you could look at timelines. Let's see, initiate regular commitment proceedings within 30 days of that determination. Again, just getting some rapidity to the process, some sense that we need to move these along. Let's see, I'm scrolling down on my screen, April. I'm not, so I don't know if you are down as well. 3634. I think that's about it for now. I mean, the other thing that I would observe about your process is that you seem to have a hard cap, or the statute implies that there's a hard cap at the end of 6 months for the restoration determination. And I've also seen some statistics that suggest that folks are there longer than 6 months now. And so I think that's something else we need to talk about, is what that looks like at the end of that hard cap 6 month restoration period in the state hospitals, and how we transition out of that more expeditiously. But I just got those statistics actually since we chatted at the end of last week. So in any event, you know, I'm sorry that that's a sort of a quick and dirty and maybe somewhat difficult presentation to follow, but I hope you see that there are mechanisms that other states have adopted to divert people from the criminal justice system, get them into treatment sooner, and thereby preserving public safety and saving money. This is not something, this proposal is not something that I think would cost the state money. It's something that would save the state money. Jails, if we can reduce the time people spend in jail. State hospital, if we can send fewer people and free up some of those beds for civil commitments rather than restoration processes. Those are, I think, goals that I think everybody can agree are worthy, and that's what we're trying to help you do. So, Justice Goff, I hope that was sufficiently detailed, but not too confusing. But glad to answer questions if there are any.
No, thank you very much, Rick. And I do want to offer any members of J-Rac or the designees to ask Rick questions while we have him. This is really a great opportunity for us to share in his expertise.
I'll just add one thing. You know, while I have no official opinion on any of this, just as a disclaimer, I'll add that when it comes to the sufficient state interest versus misdemeanor felony distinction, I would say that our experts at Logansport especially would argue pretty strongly that you can't really tie kind of dangerousness to level of offense, sort of as it is. And so I think they would, in the event they were allowed to have an opinion, they would say that the state interest standard is probably the more appropriate.
And thank you, Jay. And that's why I suggested that, because, you know, as you're well aware, you could certainly have misdemeanants who can be extraordinarily dangerous, and public safety is a real concern. And you can have felons where there is absolutely no state interest in proceeding and incarcerating them for a long period of time as well. And so that, you're right, that's the preferred approach, but it's also messier. So I get that that's a choice that you all need to make.
Thank you, Jay. Are there any questions from any members of J-Rac?
Justice Goff, I think I've got a couple of thoughts if you're weighing in, if now's the time to do that in terms of the language.
Sure.
Okay. The first thing is more of kind of a policy kind of thing, but currently, the money to assess to have the evaluation or assessment done, where that comes from is from local government's budget. And so I would point out to the council that there is a disincentive to have people evaluated, because typically your budget is pretty small. And so you have to, once that budget is gone, then the judge has to go in front of the council, county council, and ask for more money to do that. And the county council can say no. And then you're sort of in the position of, well, do I mandate the county council to get more money for evaluations? Now, when I've been faced with this, I go in front of our council. I basically say, we need to pay for this. Sorry, but you need to appropriate the money, and that's typically worked. But you are in that position of doing that. So if you have a number, and when you have multiple evaluations of the same person, then you're talking in the thousands of dollars for each one of these. And typically your local budget is not huge for this. And so there's just a few of these you can do every year and stay within your budget. And so there's a disincentive for judges that don't want to have to keep going back to their council to only really do it on significant cases. And then your only other avenue then is a pretrial conference where you kind of sit with all of the lawyers and say, hey, this is what we're seeing in terms of, is there some other way that we can sort of skin the cat at this point and not have to go through these expensive evaluations. So decreasing the number of evaluations, I think, is certainly something that can, serve the interest of local government. I don't typically, the two evaluators say the same thing. Not everybody is willing to do these evaluations either. And oftentimes they have to go to the jail or make some arrangement to go to the jail in order to do these evaluations. So there's a limited sort of pool of people who are willing to do it. And so sometimes it's difficult to find people. So that's one point. Another point is on the issue of the state interest. And I know that there's language, the proposed language talks about a significant state interest and then also a sufficient state interest. And so I don't know if that's the same standard or not. As a judge, I think it would be very difficult for me to make that. It seems like a pretty fuzzy determination in terms of and weighing that against the defendant's liberty interest. I don't know how I do that. And so additional statutory guidance, I think, might be a little bit helpful. It sounds like it's leaving a lot to the trial court's discretion, which I like, because a lot of these cases are fact sensitive, but I think a little bit more guidance in the statute would be good. With regards to this determination, I have the question whether or not victim input, if we have this hearing on sufficient state interest, are victims entitled to have some input? Is that a hearing where victims are entitled to be present? And then also, when I make that determination, I'm stepping into the prosecutor's area of discretion in terms of what they can and can't bring as a criminal offense. And so I'm wondering if you kind of how the prosecutors feel about that as well. So those are some concerns that I have about that determination. The other thing that I think we ought to provide for in the statute that we've struggled with a little bit with these is what happens to the prosecution if someone is found to be unrestorable. And I don't think our current statute necessarily says what happens to it. And so where we've landed locally is, hey, state of Indiana, why don't you dismiss your prosecution without prejudice? And I'll enter an order of dismissal without prejudice. And then if they ultimately are able to be restorable again, then you can kind of come back and bring up the prosecution again. But I don't know that there's a clear answer in our statute about what happens if you make that unrestorable decision. And I'd like to see us have that specified in the statute, because as a trial judge, I'm not sure if we're going in the right direction or not with that. And it would be nice if the statute would give us guidance there. So I know that's a lot, Justice Goff. I apologize. I had an opportunity to speak with Rick in this process, and I really appreciated that. I think this is a very important thing for us to do. I really support it. I think Jay is right that a lot of the players in the system are not real familiar with this. I got to say, Jay, I learned some stuff today, even having been through this as a result of your presentation. I think it's really important that we do this work. So my comments shouldn't in any way be reflected as a criticism of this effort. I completely support it.
That's why you're representing the Indiana Judges Association. Those are all excellent points and excellent questions. And I want to give everybody an opportunity to ask questions, but to that point, I had pre-conversations with Chris Naylor and Bernice Corley probably 3 or 4 times over the past year, and we've never had an opportunity to sit down and have any conversations of substance to get their thoughts. They're seeing this just basically for the first time as you are, Judge, and that's kind of why I previewed Rick's presentation by saying this is going to be something we're going to have to spend some time discussing to come up with hopefully some consensus on a path going forward.
Justice Goff?
Yes, please, Bernice.
So thank you so much for previewing this draft, and Rick, thank you for your presentation, and Jay, thank you for yours. So I'm very supportive of the overall idea, and I just wondered if we could talk timeline and if it would be possible for me to share this draft with defenders to get some feedback. As I look at the draft, there are a couple of things that stick out to me. So one being, of course, going down to one evaluation. My experience is my personal experience is limited to Marion County, so I understand other counties may have some unique experiences, but I definitely feel like having 2 opinions often results in a more robust analysis of a person. In my experience, when you have any process you do more than one time, sometimes there's a tendency that things become rote, and doctors use kind of, a past evaluation to make statements about current situation and so on and so forth. So I feel like there's value in having more than one opinion. But that said, I appreciate how this draft gives a process for getting a second evaluation. But my concern about that, the way you can get a second evaluation, and I love that it's open to anybody who wants to make that request, is that the standard seems, I don't like the standard. I only have one screen, so I don't have the language in front of me, but the standard just seemed really fuzzy. And I would, if we're gonna stick with one evaluation, then I think that any party, if they object or disagree or feel like they need a second evaluation, should just be able to make that request without the judge evaluating that request. But all that said, I really would like an opportunity, if it's okay, to share it with defenders who do this work in different counties to get their practical feedback and share that with the group.
And just real quickly, Justice Goff, the standard was good cause, just trying to keep it really low, to your point, Bernice.
Yeah, thank you, Bernice. I don't want to stifle any discussion today. We always seem to run short on time, but to follow up with respect to Bernice's question, and then some of the other questions that were brought up, and excellent presentation, in many ways is open-ended again. Mary Kay is going to sort of outline some preliminary thoughts on next steps. So, Mary Kay.
Thank you, Justice Goff. I mean, I think all of the feedback is very much welcome, and certainly to the extent that there are additional thoughts that haven't been covered in this proposed legislation, we would love to hear them. I think with our Deadwood group, a member of the Deadwood group is Senator Sandlin, and we are going to be convening Senator Sandlin and other legislators that he thinks are appropriate in this discussion to talk about a possible strategy for moving forward. We know that we're short on time in terms of the legislature, and so Getting these concepts to this group is the first priority. And moving forward, depending on what this group and others think should be the priority, if any, for this upcoming legislative session. For example, if there was some consensus surrounding changing the standard of review or adopting a template for these evaluations, whether that's something that could be relatively quick, straightforward, that could happen during this legislative session, and or the possibility of at least getting these concepts out in front of key stakeholders and then assigned to an interim study committee so we could really take a look at some of these issues and discussion and vetting through the next legislative session. So, I mean, I think that that's very open-ended right now. And any feedback from this group as to whether or not you all have ideas in mind of what should be a priority, with the understanding that we may need to settle on some language. But if there's anything that we think would be really useful, that is urgent, that is straightforward enough that we could accomplish in this coming legislative session. Again, with the understanding that we know that once bills are filed, there's an opportunity for feedback, things can get amended, but also building into that process an opportunity to take a deeper look at some of the larger scale issues via a study committee for next year. So in addition to the work of the Deadwood Group, I mean, this is one component of what we are doing with the behavioral health evaluation. And so Rick and I are also finishing up interviews with other stakeholders, and we'll have a report to this group by the end of December about other opportunities to improve access to care for behavioral health services. This is just a very important piece in the process, but it is a little time sensitive because we're coming up on the legislative session. We don't want to rush anything, but if anyone sees any issue that is so critical that we address in this session, we'd like to be able to do that if we can.
So Mary Kay, just to follow up, does that mean you would like a vote today on where we are, where this body is with this, or?
Well, from my perspective, I think just generally taking the group's temperature on, similar to Judge Spitzer's comments and your comments that you think that this is important, that there is opportunity for us to improve the efficiencies associated with the competency evaluation and restoration process. There are other things, and this is from a legislative perspective, there are other parts of this initiative that I think could go a long way to improving the process. Increased use of community-based restoration services, for example. So this is part of a much longer conversation. So I guess the only thing I would say is, to the extent that any member is willing to express support, we would love to hear that. But also to the extent that any member has specific concerns about moving forward with any of these conversations, we would like to be able to hear those concerns so that we can either reprioritize or shift the focus of this discussion to address those concerns.
Thank you, Mary Kay. I mean, as I shared, my comments aside, I'm very supportive of this draft, and I think it's a great start. And
the only thing that I would add to that is that, to the extent that this moves forward, of course, every member of this body, whether in their capacity with the council or outside of their capacity of the council, would have an opportunity to weigh in on this. And similar to what we are looking for with the local J-Rac discussion, is we just want to make sure that everyone's needs are met, everyone's concerns are addressed to have the best product possible. So even if this group decides, conceptually that this is something that the council wants to support, as we move through it, we understand that everyone will have to look at specific language and weigh in as appropriate for their constituency.
David Bodworth had a couple questions, if I may.
Please, Dave.
Following up on some of Judge Spitzer's comments, do we know how many orders are currently done each year for the competency test? Is that data that we have so we can kind of evaluate how much that cost? And then would there be, I don't know how you do some kind of an algorithm to see what the increased cost may be for the counties, are there going to be more and more people who go through this evaluation, which I think is probably a good thing, because every time I have a conversation with a county commissioner, council, or sheriff, it's always, if we get the mental health people out of the jail, we'd have room and wouldn't be overcrowded, and they'd be getting better service and treatment. So I definitely support the concept of doing these evaluations. I would just be concerned about, again, the fiscal cost and how many may be ordered. And I don't know if other states have a dedicated revenue source to this, or if, again, this is something that the counties come up with on their own based on need. So.
Excellent question, David. Thank you. Jay, do you have at your disposal a number corresponding to the number ordered?
Not at my fingertips now. I can get it. We have a person that keeps track of all those, so I can certainly get that very quickly.
Yeah. You know, moving forward, then Mary Kay has kind of outlined this. It's sort of messy, unfortunately. All of these ideas are when trying to identify the problem and come up with some sort of consensus solution. But Mary Kay, is it fair to say then that this is an idea that we want to make sure you're worth the temperature of the group? We've got another meeting scheduled yet this year. We've got some conversations that will need to be had with legislators. I think it's expected and it's important that we hear from IPAC on this. I think Bernice does need to have an opportunity to go back to her constituents and get their input. I know that Steve Luce will have some thoughts and concerns that he'd probably like to share with a group like that. And I'd really like to get some of that information that David asked for so that he could share with his members sort of an idea of costs, savings, and cost might be associated with any change. Would it make sense then to, again, table this until next month, and then kind of ambitious, but hopefully identify at least 3 or 4 members, and then open up an invitation to anybody else who want to participate? 3 conversations between now and the next meeting.
That sounds good to me. And I just had to, I'm going to be hitting the circuit a little bit with going to talk to the sheriffs, and I need to get back with you, Dave, on some dates to talk to county commissioners. So I think there'll be some important legwork done between now and then too.
Well, sure. And Mary Kay, if you've got different thoughts logistically, you're the one who's putting these things together. But I just trying to get an idea of what your ask is and what your needs are for the group.
Well, thank you, Justice Goff. I think the one thing I would say is that with Senator Sandilands' involvement in the Deadwood conversation and his participation in the summit, I know he has some significant interest in looking at least proposing a study committee for next year. So at a minimum, I would offer to this group that I think they could expect some language to that effect to be proposed by Senator Sandlin or one of his colleagues to get this discussion moving. I think that would be the minimum. And I think it is possible that there may be some other discussions around legislation that may be happening that we're not familiar with or we're not a part of right now. But I do know that serious mental illness is on the minds of many legislators. So this is just one opportunity for us to help try to address some of those issues. But there could be conversations going on that we're not aware of, and we can keep J-Rac posted on this. I know this is a very nebulous concept right now, but I know that we are hearing, from the sheriffs, from the courts, from the parties, that there is a need to make some adjustments in this process. And I think this is a first attempt to try to address some of those issues, and we may need to, continue the conversation moving forward. So I guess at a minimum, Justice Goff, I'm asking for any member who has serious concerns or objections to continuing these conversations to consider those and to voice those concerns and let us know how we can address them.
All right, thank you. So that's the question. Are there any objections to or serious concerns with continuing the conversation? well. Well, hearing none, I'm really happy that we're having this conversation, and I'm confident, difficult as it might be, that going forward we'll be able to come up with some plans and some ideas that will help people and will improve upon what we have here in Indiana. I want to take just a brief opportunity to express my appreciation to Rick, to Patty, to Jay, Doug, all members of the Deadwood group, and everyone who's participated in the mapping exercise thus far. And I look forward to working with you all in the time to come. Thank you. I'm going to move on then in our agenda to item 5 and member discussions concerning budget forecast and local impact. We have over the past several months received some report out from Senator Talion. I don't believe Senator Talion was able to join us today. And I would ask also for a report out then from Kirsten Haney, who's also been kind enough to give us updates periodically. Kirsten, do you have anything to share this morning?
Thanks. I don't. The only thing we have scheduled is that revenue forecast that's occurring in December 16th. So that's our biggest item that really helps project out the budget for the next 2 years. So that's the only, update on my end with that.
Thank you. We appreciate your participation in these meetings, Kirsten. I'm going to next move on then to our member reports. And I'd first ask for a report out on behalf of the Probation Officers Professional Association of Indiana. And I believe today we have CJ Miller appearing as proxy for Adam McQueen. Good morning, CJ.
Good morning, Justice Goffman. Thank you very much. I have discussed with the President, Adam McQueen, and our Vice President regarding any updates, and we don't have any at this time from the Council.
Well, thank you, and thank you for participating and serving today. It's good to hear from you. And Kirsten, you're next up. I hate to call on you again. Is there anything else that we need to consider from the budget agency?
Well, I will share with everyone that keep an eye on the SBA website. So it's www.in.gov/SBA. So December 14th, 15th, and 16th, we're going to have a series of budget hearings for various cabinet level agencies and separately elected. So that's a really great opportunity to kind of tune in and just hear those agencies present on their budgets, give a little bit more detail on it. That is hosted by the Budget Committee. And then the revenue forecast is December 16th. And I believe actually this Wednesday is the university budget hearing. So that should be on the 18th of this week, I believe. So just a couple updates as far as how that progresses. And then we are still on track with releasing governor's recommended budget by the end of December. Statutorily, we have to have it done by early January, but I know we're definitely trying to get everything done before we head into holiday season. So those are the only other updates I have on my end. Thanks, Justice Goff.
Thank you. And I neglected to give any members opportunities to ask questions. So before I move on, were there any questions from any members for either CJ or Kirsten? Hearing none, then I'd ask for a report out on behalf of the Association of Indiana Counties from David Bottorff. Good morning again, David.
Good morning. Thanks. Just a couple items. One, last week on one of our calls, the county clerks had mentioned many of them had excess PPE from the elections. And I think I sent this note to April that if the county has excess PPE and there's a storage issue, that they can share that with, they do have authority now to share that with other county offices or local units of government. So I think that's good news for, to help the courts and public defenders, probation officers and others who may have a need for PPE. A lot of the counties had quite a bit left over. So that's good news. And then we're continuing to track the CARES Act money. you know, ever since this federal government authorized that to be used for public safety salaries, most counties are now turning in those claims for public safety salaries. We do think that will make it much easier for the audit perspective and to get that money back to the county. So last time I checked, I think 150 million of the 300 million available had been requested and distributed. We're continuing to monitor to make sure that all the counties take advantage of that. So that's good news. And again, the state has not put a deadline on when the counties have to have that request in. The federal government deadline is still the end of the calendar year, but as of now, there is no deadline for the counties other than the end of the calendar year. So that's kind of all we have to report at the moment, but appreciate these meetings and being part of this discussion. It's very educational for me, so thanks.
Well, thank you, David. Are there any questions from members for David? Well, David, we appreciate your participation, and I expressed my after the Justice stakeholders call last week. I know the ability to share some of that PPE will be something that will be much appreciated by many judges and justice partners. Thank you. Next, ask for a report out on behalf of the Indiana Judges Association by Judge Mark Spitzer.
Thank you, Justice Goff. Our primary focus as the Judges Association at this point is the court operations during the pandemic. And obviously, as we've seen numbers increase, then that's really kind of put courts in a difficult situation. The Supreme Court issued an order on November 11th with regards to that. And then this morning, the president of the Judges Association, who's also on the resuming court operations task force, sent out a guidance to counties based upon what zone the counties are in and how they should conduct court operations. Courts are open. We're required by Constitution to be open, and we are open and continuing court operations. But where there was a period of time we had kind of moved towards normalcy. We're in a difficult period of time now as numbers increase. Just for my personal situation, I had 2 successful jury trials, and then I had a 2-week murder trial that had to be ultimately a mistrial declared because of COVID. And so particularly with longer jury trials, the question is what do we do about trials and criminal trials as well? Most civil trials have kind of been bumped out. Criminal trials have a little bit more urgency, and so sort of navigating that issue is the most difficult question that we have at this point. Using our technology for other types of hearings has worked pretty well, but we have other issues that are out there in terms of probation supervision, how do problem-solving courts operate, and things like that we're navigating as well. So that's sort of the challenge that we're facing at this point. And so that's going to be an ongoing sort of challenge for us to work through. And we're hopeful that things will get better in the future. We'd love to be back to normal at some point.
Well, thank you, Judge Spitzer. Are there any questions from members of the council for Judge Spitzer? Very well. I next then ask for a report out on behalf of the Public Defender Commission from Mark Rutherford.
Thank you, Justice. I'm sorry. Thank you, Justice Goff.
Thank you.
I just want to tell everybody that with this budget session coming up at the General Assembly, we submit our own budget. We're not normally under the budget of the governor or the Chief Justice. So we, from our analysis, the more work we do, the more we see that what we're doing is saving the state money, keeping kids in DCS at a better appropriate time, making prison sentences more appropriate, not too long where they shouldn't be, and helping reduce the jail population, among other things that's going on out there. So we hope that we don't get into a situation after the budget session where we have to prorate. And by law, if we run out of money or don't have enough money, we just prorate the reimbursement to the counties. I was on the commission the last time that happened, and it was not very popular, to say the least. We hope that doesn't happen. We hope that the General Assembly is able to meet what we need for our budget to continue doing what we are doing. We had Elkhart County join this last fiscal year. It's a large county. We now have up to 64 counties in the commission system, and we have 4 counties that are working with us to join too. So we want to keep working with them and doing what we think is long-term, a very wise financial and good for justice, and doing justice in the best way. If any of you have any questions, please feel free to contact me, contact Derek Mason about our budgeting, about what we're doing. We'd be more than happy to do so, and we enjoy to do it. And we thank all of you who are concerned about what we do, how we do it, and all of your support, and we appreciate it greatly. Thank you.
Thank you, Mark. Any members have any questions for Mark? Very well. I next asked in for a report out. I hope that Doug is still with us. I know he had a meeting he had to jump off. Is Doug still on the line? Doug?
I am here.
Oh, good. Good morning, Doug.
Good morning. Thank you. I don't have a substantial update at this time.
Very well. Any members have any questions for Doug? All right, thank you for your participation today, Doug. I know you were very busy. I appreciate it. I next then ask for a report out from Bernice Corley on behalf of the Public Defender Council. Bernice, are you still on? I'll come back to Bernice. Ask then for a report out on behalf of the Indiana Prosecuting Attorneys Council by Chris Naylor. Chris?
Thank you, Justice. Just reaching back to the competency issue, I enjoyed meeting Rick over a Zoom call and enjoyed talking with him and Mary Kay about the mapping process, and we certainly welcome the conversation on this issue and appreciate the approach on seeking consensus. And if there's consensus soon on certain items, great. If things need to wait till a study committee next year, that we certainly welcome the study committee approach too. So I just wanted to voice that position. Similar to Judge Spitzer, prosecutors, dealing with the COVID and the dilemma of the jury backlog. During 2020, there's been a great backlog of cases that just need to be tried to a jury, and it's a dilemma now as if safety requires us to slow down. It's not a great thought to add to that backlog now, but we will persevere in working with all of our partners, and there will be an end to this. So,
yeah, Chris, boy, I really appreciate your participation on behalf of IPAC, and you've been a great justice partner through this. So thank you. Are there any questions for Chris from any members? Very well. Ask then for a report out from Jay Chaudhry on behalf of the Division of Mental Health and Addiction.
Hi, sorry, my connection's unstable, so I took my video off. I have nothing in addition to what I already presented on. So, the Recovery Works report is in, and that was presented to the Commission to Combat Drug Abuse last week. At some point, if J-Rac wants, we can do a similar thing for J-Rac. But the bottom line, I think, is the program and sort of its last iteration has shown some pretty significant improvements in recidivism. So I think it's working as intended.
Thank you, Jay. And I'm sure we'd love to have that information. Maybe we can follow up with you about getting some of that information. Are there any questions for Jay from any members? Okay, hearing none, I'm going to circle back then to Bernice. I understand Bernice is back on, so ask for a report out from Bernice Corley.
Sorry, my computer froze. I don't have a report out at this time.
Well, Bernice, just as with Chris, I want to express my appreciation for your continued participation in the Justice Partners calls throughout the challenges of the pandemic. It's been very helpful to have you participating in those. So thank you for that.
Thank you, Justice. Glad to be a part of it.
Any questions for Bernice from members of the council? Next, then, ask for a report out from Steve Luce on behalf of the Indiana Sheriff's Association.
Thank you, Justice Goff. First of all, we've had a rise in COVID-19, not only with offenders, but some of the sheriff's staff. And we have been really working hard with the Department of Corrections. Matter of fact, we're starting back up almost weekly, bi-weekly calls to make sure that we have all the resources, all the protocols, just a reminder to the sheriffs and their jail commanders. And we've also worked with the Department of Health through DOC2 to start a distribution plan to get some of the rapid testing for COVID-19 to Bionex cards in distribution, and working with the medical providers to the sheriffs. I think that's going to really help them quite a bit. That we are seeing some spikes here in the last 2 weeks in several counties in the jails. I do want to give a shout out to Jay Chaudre for talking about the restoration piece. And, you know, I do have quite a bit to say about this, but I'm going to make it short in the fact that we need to make this a priority. Getting these individuals the resources and out of the jails, even if it's 1 or 2 in a jail, I can assure you that it will allow the sheriffs to manage a jail it's more manageable, simply because of those people take up so much time. And I do want to also thank Judge Spitzer and Rick for their work and their comments on this. And this has been an issue for several years, and I'm very glad to see that as a state we are addressing this because I think long-term, as a retired sheriff, I always think about liability and litigation the sheriffs have to deal with. And I think just by taking these steps, we'll relieve a lot of counties of potential litigation in the future. So I appreciate that. And I would probably ask that we also now, as we go into the budget session too, we also have to look long-term. Jay is working on a short-term solution, and then we also have to tackle the long-term solution. So it's going to be mapped out very well, and I appreciate the work everybody's doing. The Sheriff's Association, thanks to the governor's office and DMHA, we have been overseeing the state opioid grant. Right now we have 17 counties that are expanding MAT or other services in their jails for their offenders, and they're partnering with their local either medical provider or other county provider for services. As an association, we are working with our law enforcement partners and Representative Sturwald on a very good police enhancement bill, which is going to focus a lot on the decertification process. We also, maybe at a later date, myself and DOC, Dr. Doss, maybe we could give an update on our short trip to Nashville, where the jail there in Davidson County, they have a new behavioral care center, which I think could be, pieces of that could be something we could maybe regionalize and help out all our stakeholders there. And also, I sent out an invitation to everyone, I think. If I've missed, you let me know. But Wednesday, the ISA, we also look into resources or how can our current business partners support our sheriffs. But there is an invite out there on Wednesday, November 18th at 10 o'clock. You can either come to our office or virtually, but it is with a company called Warrant Now and Court Resolution, which I think the whole purpose of bringing that to everybody is to look at other options using technology that could help them through their court processes, seeing that things are probably going to get backed up again. And just to finish it out, just keep the jail overcrowding project that we did before COVID just out there, because we put a lot of work in that. Other than that, Justice Goff, thank you for your leadership, and everybody else, thank you.
Well, Steve, thank you. And thank you especially today for keeping this idea of competency restoration in the forefront. I know your leadership through this has been very instrumental, and it's very important for folks to hear from you and the challenges that our sheriffs are facing dealing with this very vulnerable and very high need population of folks. So we really appreciate that.
Thank you.
Are there any questions for Steve before we move on? Thank you again, Steve. Next, I'd ask for a report out from Christine Blessinger on behalf of Commissioner Carter and the Indiana Department of Corrections.
Thank you, Justice Goff. So as Steve said, yeah, I thought maybe I would talk about a couple of some collaborative efforts so that we are also participating in. As Steve said, we're working very closely with the jails, you know, just giving them assistance, doing calls, just working with them, you know, as they see a rise in cases. We've also been participating with the Justice Partners calls. Last week, we just want to make sure that we are updating everyone on the status of what our intake process is, our intakes, our plans to continue with intakes. We know that, you know, as we see a rise in cases too, we want to make sure that we're doing things safely. And we've been collaboratively working with the jails, the jail commanders on bringing in our intakes. Let's see, also, I'll just update on the community corrections contracts. I know that we've been, all the contracts have been sent out to the counties, and we have received most of them back. We are in the process of just making sure that we're signing them, getting them signed and through the process, and everything seems to be going smoothly with those. So we should be complete with all of that coming up. That's all I have. Thank you.
Thank you, Chris, and thank you for your responsiveness. Whenever we've had a question throughout this, I so appreciate your willingness to engage and be responsive for these very challenging times. Are there any questions for Chris on behalf of the Department of Corrections? Very well. I next then ask for a report out from Mary Kay on behalf of the Office of Judicial Administration.
Thank you, Justice Goff. As Judge Spitzer mentioned, our office is working closely with the Indiana Judges Association to provide support to the trial courts and probation departments during the time of the pandemic. We see in many counties that this is changing very rapidly, and so there's a need to really remain in close contact with the courts to find out how we can provide support to them. So I would encourage you to continue if you have access, well, you certainly have access to our website that provides guidance to the trial courts and supervision agencies on COVID and pandemic operations. We are updating that as soon as we receive information, and it often includes information that is specific to certain types of proceeding or case types. In addition to that, our office is continuing business as usual when it comes to conducting certification reviews for problem-solving courts and pretrial services and A&D programs. We're also continuing to provide education. We're doing probation testing, risk assessment testing, some of which is being conducted remotely. So we're just trying to stay in close communication with our supervision agencies so that we can continue to provide them support. And I think that's all I have to report.
Thank you, Mary Kay. Are there any questions for Mary Kay on behalf of the Office of Judicial Administration? Hearing none, then I'd ask for a report out from Devin McDonald on behalf of the Indiana Criminal Justice Institute. Devin?
Thank you, Justice Goff. Can you guys hear me okay? I've had some computer troubles today as well.
I can.
Okay, great. Thank you. Not much to say today. Obviously, we've been impacted a little bit just being here in Marion County with COVID operations and whatnot. We are the two big projects we're working on right now. We're finalizing review of our annual 1006 report that we do in collaboration with this committee, as well as continuing to evaluate and push forward on both the victim notification project and the associated data project with those. So making some headway on those two projects. And again, hopefully here in the next few weeks, we'll have some more updates on that. That's about it.
Well, Devin, appreciate your participation throughout, and appreciate your willingness to help us assemble this important information.
Thank you.
Are there any questions for Devin? Right. Hearing none, then I'd ask for a report out from Ralph Watson on behalf of the Association of Community Corrections Act Counties. Good morning, Ralph.
Morning. Thank you, Justice Goff. We really don't have a report to make at this time. Not a great deal going on. As Chris said, I think everyone's getting their contracts back to the Department of Corrections for their community corrections grants, and we would like to commend them for getting those out as quickly as possible during a very pressing time.
Thank you very much, Ralph. Are there any questions for Ralph before we move on? Well, that concludes our report outs from members. Just give one last call for any additional items that I might have missed or any members that I might have failed to call upon. And hearing none, then I'm going to move on to agenda item 8, other business. We are unbelievably here near the end of the year. And I think it's appropriate then to set plans for our meetings in the first part of calendar year 2021. Given the unusual challenges that have been presented in 2020 and the fact that we're in a budget year, I would like to propose that we continue throughout at least the first part of 2021 to continue to meet monthly as opposed to bi-monthly. I know that it's an ask, but I really think that these meetings are productive. And so if you'd look at the agenda that was distributed ahead of time, we have some proposed dates, which are Friday, December the 11th from 1:30 to 3:30, Friday, January 29th from 1 to 3, Friday, February 26th from 10 to 12, and Friday, April 22nd from 10 to 12. And if there are no immediate objections to those dates, April will be sending out calendar invitations for those dates, but we can, of course, revisit a proposed meeting date if there's a significant scheduling conflict. So just preliminarily, is there any, jumps out and screams at you that none of those dates will work or problem with that concept? Very well, hearing none, I'm going to remind members that our next meeting is scheduled for Friday, December 11th, and that will be from 1:30 to 3:30 p.m. An invitation for this meeting will be forwarded to members. At this time, I want to thank you all for taking time to participate in today's meeting and for your continued work serving our Indiana communities. Thank you again, everyone. Have a great day.
Thank you, too.
Thank you.